All right, everyone. Welcome back to Week Two's lecture. This week we'll be discussing the foundation of U.S. government, which is the Constitution of the United States. Through this week, we'll learn how the Constitution was developed, why it is needed, and start learning about the different types of power the Constitution bestows upon various parties and institutions. I hope you all have your pens and paper ready to take notes, as this journey is going to be intense but very fun. So let's begin. Well, actually, before we begin, let's just go over a couple of things. So please make sure you have read Chapter 2 of the Openstax text, as well as the Constitution, so that you have a solid foundation for the discussion. You should be able to find the Constitution on the front page of the Lessons section in Blackboard. It should be under your textbook link. All right, now that we have that out of the way, let's begin. Before we completely dive into the history of the Constitution's development, I want you to take a look at this picture. What is this a picture of? If you said the preamble, you would be right. This is the preamble of the Constitution of the United States. Note how this magnificent document starts with, quote unquote, "we the people." As we are going through the history and throughout the semester, I want you to be thinking about the preamble. Does the Constitution really mean we the people? The U.S. Constitution was created in September of 1787, making it the oldest written constitution remaining in effect. The framers of the Constitution drafted the document during a period of ineffective national government under the Articles of Confederation, which we will talk about. The Constitution was created through a series of significant compromises among factions that favored strong federal government over strong state governments, states that had different and often competing economic interests, and those concerned that more federal power would reside in the more populated states at the expense of the smaller states. So you will see that there is a lot of concern around state versus federal as we go through the development of the Constitution. All right, so that's a snappy introduction. Let's go further. So let's start with talking about the foundation for our laws, which date back to England. So remember this dude, John Locke, from last week's discussion. Hopefully everyone remembers him. If you remember, I highlighted the concept of liberty as it was the backbone of our democracy. During that discussion, I told you about a 17th century philosopher named John Locke. Locke was one of the most influential thinkers of the Enlightenment era, and much of his writings form the basis of modern politics, including his notion of liberty. Remember, Locke was the one who first proposed the idea that people should be free to consent to be governed, which is the foundation for any democracy, being that people agree to the social contract that allows government to do its job. Locke's ideas of natural rights conflicted with the long-held belief in England and most of Europe that God had granted temporal rights to a hereditary monarch. So Locke's ideas about life, liberty, and property can be traced back to the Magna Carta of 1215, in which the English monarch recognized certain individual rights of a free man. The Magna Carta was the cornerstone of liberty for England. In its inception, King John promised that the monarch's actions would do no harm to the people. However, after King James II was deposed, the English Parliament passed the English Bill of Rights in 1689, which further enshrined liberties and protections afforded to its citizens. And before we go into the American Revolution, it's very important that we realize that during colonial times, the the people were still British citizens, and they were happy until England started talking about taxation. So, at the core of the American Revolution, it came down to English imposing taxes on the colonies. They were upset due to not having representation in the British Parliament. The colonies argued that this lack of representation on the decision to raise taxes was a denial of their rights as British citizens. So while they were British citizens, they did not have the representation in the British Parliament because they had settled the new lands. And so when the British Parliament decided to increase taxes, the American colonial colonists decided that, hey, we didn't get a say-so in this, and we don't really agree with this. And to further add fuel to that fire, the Stamp Act of 1765 was passed by Britain. The act required that almost all paper goods, such as land, deeds, and contracts, which the colonists were dealing with on a pretty regular basis, had to have revenue stamps placed on them. Then there was the Townshend Act of 1767, which further imposed taxes on everyday items such as tea. Following the threat of a boycott of British goods by the Massachusetts legislature, Britain sent additional troops to Boston to try to get them under control, where in March of 1770, the Boston Massacre happened. And basically, the Boston Massacre was where the British troops fired on groups of citizens and killed 3 of them. All of this was because the American colonists were at a philosophical war with Britain and kind of breaking free because they felt that their rights as British citizens had been taken advantage of. Following further unrest in the colonies, including the Boston Tea Party of 1773, Parliament passed the Coercive Acts of 1774, which essentially denied self-rule in Massachusetts. Enraged, the colonists formed the First Continental Congress to oppose British rule. On July 2nd, 1776, the Second Continental Congress declared the independence of American colonies from British rule with the signing of the Declaration of Independence on July 4th, 1776. That declaration, the Declaration of Independence, basically reflected John Locke's view of the colonist right to self-governance and individual right to life, liberty, and the pursuit of happiness. This is a picture that is supposed to depict the signing of the Declaration of Independence. As you can see, it was commissioned to hang in the Capitol in Washington, D.C. This picture is sensationalized, however, as not everyone was in the room. This picture makes you think that everyone was in the room to sign the document and it was this big to-do. While it was a significant event, not everyone was in the room. The picture is meant to show that there was a unified force. And while there was a unified force, it didn't quite go down as this picture depicts. So I want you to imagine the media sensationalizing the news? Does that really happen? Well, we will have a complete conversation around the media later in the semester. But this is just one of the things that I found quite interesting this week to kind of foreshadow some of our conversations to come. So after the Declaration of Independence was written and and adopted, I guess you could say, Britain declared war on American colonies following that signing. Faced with a military campaign against a powerful opponent, the colonists recognizes they needed to launch a coordinated war effort. Because remember, there wasn't really a national government in terms of a unified government with the American colonists. Each colony had its own separate government, and so now after this unification force has come together, with knowing that there's an impending military campaign from Britain, the colonists come together. So in November 1777, the Continental Congress approved a framework for a new government under the Articles of Confederation. So that might be something that we want to remember. The Articles of Confederation. The Articles of Confederation required the approval of all 13 colonies. However, Maryland withheld its approval until March 1781. After a series of defeats by the colonial army and its French ally, the British army surrendered in Yorktown, Virginia, in October of 1781, effectively ending the American Revolution. So really, the Articles of Confederation were the first agreement between the colonies to have a unified government. That is something you probably want to remember. With the ratification of the Articles of Confederation and the end of the American Revolution, the 13 original states had to create a working government under the terms of the Articles. They provided for strong self-governing states and a weak central government. So remember, when the colonists came here, they were getting away from a British monarch. Taking us back to our conversation last week with monarchy. So in some of the colonists' views, they really wanted the states to have power because they feared that a centralized government would be too much like a monarch. So the Articles of Confederation were crafted specifically to give states more powers than the new centralized government. The states agreed to cooperate at the national level in limited areas such as defense. And here, your book does a really great comparison because there were several problems with the Articles of Confederation. And I kind of want us to talk about those. So the national government could not impose taxes on citizens. It could request money, but it could not impose taxes. Because some of those requests weren't honored, the national government didn't have the money to pay for a national defense or fulfill other obligations. So back then there wasn't a U.S. military. There wasn't a centralized defense because the defense was left up to the states and their powers. The national government could not regulate foreign trade or interstate compact. It could not prevent foreign countries from hurting American competitors by shipping inexpensive products to the United States. Could not prevent states from passing laws that interfered with domestic trade. It really could not regulate state authority. It could not raise an army. Armies were left to the states to raise. So we're now our centralized government can really take command over the Army and National Guard. There was no such thing back then, and that was purposeful because remember, with the creation of the Articles of Confederation, the states didn't want the centralized government to have too much power. The articles could not be changed without a unanimous vote to do so. So these flaws within the articles could not be easily fixed unless all 13 colonies agreed to do so. And then there was no judicial system. And as we go through, we will find that our judicial system is a very important part of American government. And so that was very problematic that there was not a judicial system back then. All right, so while several people knew that the Articles of Confederation had their weaknesses, that was really highlighted and brought through a spotlight through what was known as Shays' Rebellion. In the summer of 1786, farmers in Massachusetts who were heavily in debt, facing imprisonment and the loss of their lands because they owed taxes that had gone unpaid while fighting against the British. The Continental Congress had promised to pay them for their services, but the national government did not have sufficient money to pay them. Because why? The Articles of Confederation did not allow a centralized federal government to raise revenue. Moreover, the farmers were unable to meet the new tax burdens Massachusetts had imposed in order to pay its own debts from the Revolution. So what you see here is a picture that depicts Daniel Shay, who was a heavily indebted farmer, and he led a march to the local courthouse demanding some relief. Faced with the refusal of many Massachusetts militiamen to arrest the rebels with whom they sympathized with, the governor James Bowdoin called upon the national government for aid, but none was available. The uprising was finally brought to an end the following year by a privately funded militia after the protesters' unsuccessful attempt to raid the Springfield Armory. Shays' Rebellion really highlighted the deficiencies in that the Articles of Confederation placed on a centralized government. So with the highlight from Shays' Rebellion, in 1786, a convention was called to revise the Articles of Confederation, but it failed when only 5 states sent delegates, because remember, as part of the Articles of Confederation, all 13 states had to agree. The second convention was called to meet in Philadelphia in 1787. Only 12 states sent delegates to the Philadelphia Convention, so revision of the Articles of Confederation remained impossible. The delegates to the Philadelphia Convention therefore decided to scrap the Articles of Confederation altogether and form a new government. They faced numerous points of contention among the states at this delegation. So some of those are highlighted on here. They faced the strengthening the national government, but maintaining a high level of state power. So that fine balance between federal and state power. They wanted to protect the power of small states and a new national government from the power of more populous states. And they continued to want it to permit states to allow slavery. Slavery was still a big issue here. And so these were all kind of points that had to be worked out in this in this new government. Two competing plans for state representation at the national level were proposed at the convention. You've read about them, and you should get familiar with them. The first one was the Virginia Plan, and it provided for representation in a bicameral national legislature with the number of representatives from each state based on population. So bicameral means two houses. On the opposite side, the New Jersey Plan provided for a unicameral national legislature with equal number of representatives from each state. So the Virginia Plan called for bicameral national legislature with representatives from each state being based on the population of that state. The New Jersey Plan called for one national legislature with equal numbers of representatives from each state. Here you will see just a picture that represents what was just stated with the Virginia Plan and the New Jersey Plan. So delegates from some states favored a strong national government with the power to tax, raise a standing army and navy, and regulate interstate commerce. However, delegates from other states feared that a strong national government could be used to deprive citizens of individual liberties as the colonies experienced under the British Parliament. The belief of some delegates that a strong national government could deprive citizens of individual rights clashed with the desires of other delegates for increased security and stability provided by a powerful national government. So what do we have to do when we have two competing interests? We have to make compromises. And this was no different with our founding fathers. So while the need to replace the Articles of Confederation were clear to most delegates at the Constitutional Convention, disagreement over numerous issues threatened to derail the process. So after extensive debate over the Virginia and New Jersey Plan, a delegate proposed what was known as the Great Compromise. And really, the Great Compromise took the best of both the Virginia and the New Jersey Plan and based it into what we have today. So the Great Compromise called for a bicameral legislature, or bicameral legislative body, which means two houses. Representation in the House of Representatives would be based on each state's population, which was a component of the Virginia Plan, and representation in the Senate, which would be a higher house, would be consistent on equal number of representatives from each state. So you're taking from the New Jersey Plan. Regarding the election of legislators, the Great Compromise provided that members of the House would be elected to two-year terms by popular vote of the eligible voters in each state. And then the state legislatures would elect members of the Senate for 6 years. So basically, how these people came to represent was the states would vote for their delegate to the House, and then the delegates of the House would elect the members of the Senate. Slavery was still a major issue that we had to overcome, and a very contentious point of contention. So after the American Revolution, the legislature of some northern states required the immediate and gradual abortion of slavery. Southern states, however, called for retaining slavery to support their agricultural economies and for the apportionment of taxes and representation. Therefore, we had to make another compromise. And this time, it was how are slaves going to be counted in a state's population? So the delegates also debated whether slaves should be counted toward the population of each state for the purposes of congressional appointment. Southern states, which had higher populations of enslaved people, argued that definitely slaves should count as 1-to-1 for each state's population. However, under the terms of the Great Compromise, this would have increased the number of members to the House of Representatives allotted to slave states in the South. Northern states opposed this because it would make each state's population disproportionate. So then we come to what is known as the 3/5 Compromise. The 3/5 Compromise was a way to count enslaved persons as part of the population. As you can see, there were two proposals. So I'm going to get my pointer. So you'll see here, it was a 1-to-1. So 5 citizens equal 5 votes, 5 enslaved persons equal 5 votes. So that's a 1-to-1. The second proposal, 5 citizens equaled 5 votes, 5 enslaved persons equaled 0 votes. All right. So proposal 1 was the Southern, proposal 2 was the Northern. So in order to compromise, our founding fathers came to what's known as the 3/5 Compromise. That might be something you'll want to take note of. So under the 3/5 Compromise, you still have the 1-to-1 of the citizens, which are, when we're talking about citizens here, we're talking about white man. Women did not have the ability to vote. Enslaved people did not have the ability to be counted in the census, or I'm sorry, be able to vote or anything like that. So we're talking about really white men. And so the 3/5 Compromise, it's a 1-to-1 for citizens. So for every 1 citizen, you get 1 point for delegate. 1 citizen counts as 1 person on the U.S. Census, which is used for delegation. However, as part of this compromise, they came to terms that you are able to count all free population and 60% of the enslaved population, which is every 3 out of 5 slaves. All right? So the 3/5 Compromise resolved the dispute over the inclusion of slaves in each state's population for the purposes of congressional appointment. Under this agreement, each state's population would be considered the total number of each state's free citizens plus 3/5 of the total number of each state's slaves. That did not end the debate around power and checks and balances. So the debate over the power of the national government consumed much of the discussion at the Continental Convention, as many delegates feared that a strong centralized government and a strong executive branch in particular could become tyrannical. So they were afraid that of the monarchy that they had left back in Britain. Delegates resolved this debate by implementing a separation of powers and a system of checks and balances. So they were very careful to make sure that our country never got back to a tyrannical monarchy like they saw in Britain. All right, so the separation of powers was ingrained in our Constitution through the first 3 articles written in the Constitution. So let's take a look at those. Article 1 laid out the legislative branch, which, again, the great compromise that we talked about, taking the best of the New Jersey and the Virginia plans and putting them together to create our Congress. So Article 1 really laid out the House of Representatives and the Senate. Article 2 laid out the executive branch, and it provides for the U.S. President to serve as head of state, head of government, and commander-in-chief of the United States Armed Forces. Then we have Article 3 laying out a judicial branch, which is brand new because, remember, the Articles of Confederation did not have a judicial branch. So Article 3 of the U.S. Constitution established the Supreme Court of the United States, and it allows for the creation of lower federal courts through congressional action, which basically means that the U.S. Congress creates those federal courts. So in essence, we have three separate bodies of government in our government, three branches of government, as you've heard, hopefully throughout your academic career. So you have the executive branch, which encompasses the presidency. We'll learn all about the executive branch. I believe that will be the week before before spring break. But basically that sets out the responsibilities for the president and his or her powers and responsibilities in conducting foreign affairs and appointing judges and ambassadors, pardoning, vetoing, utilizing his power as commander-in-chief, things like that. Then you have the legislative branch, which is Congress, and its powers to pass legislation, declare war, the Senate to ratify treaties, advise and consent to the president's appointments, impeachment proceedings, things like that. And then you have this newly created branch of government, which is known as the judicial branch. And that is the Supreme Court, and we will learn all about it. It actually is one of my favorite branches of government to study. But basically, the Supreme Court has the power to declare laws and actions by the executive branch unconstitutional. And each of these three branches were created and given power to check and balance each other's power. So the Constitution defines the separate powers of each branch of government. The legislative branch has the power to make laws, the executive branch is charged with enforcing laws, and the judicial branch tries cases arising under federal laws and other instances defined by Article 3 of the U.S. Constitution. The Constitution provides a system of checks and balances to ensure that one branch of government doesn't exceed its authority. So while Congress has the power to pass legislation to become law, the president is authorized to veto or reject the legislation and prevent it from becoming law. The Constitution, however, grants Congress the power to override presidential veto with 2/3 vote in both the House and the Senate. So you can see how legislative powers kind of fluctuate while the legislative branch and the executive branch each have a part to play in that. They kind of balance each other out. Congress may also limit the president's otherwise expansive powers over foreign policy by rejecting presidential nominees and ambassadors or refusing to ratify treaties. While the president is commander-in-chief, Congress is the one that has to approve a declaration of war, and they can check the presidential executive power by denying that request or funding military actions. The Constitution established a federal system of government in which power is divided between national and state governments. All right? And it did that in such a way where we have two really different types of power. So it's very important. I want you to pay attention so that you don't get confused on this. So enumerated powers, let me find my highlighter. Enumerated powers are those that are explicitly granted to the national government in the Constitution. So think back Article 1, 2, and 3. Those lay out enumerated powers. All right? All powers not explicitly granted to the federal government are reserved to the states. And these are known as reserved powers. So you have enumerated powers and you have reserved powers. All right? Reserved powers are those that are not laid out or expressly stated in the U.S. Constitution. In areas in which both the federal and state governments have powers to act, there is a clause in the Constitution known as the Supremacy Clause. And it states that federal laws and treaties made by the U.S. are the supreme law of the land. So the federal law supersedes any state law. That is the Supremacy Clause. This is a picture from your textbook that really kind of illustrates some of the real-world application to the Supremacy Clause and reserved powers and enumerated powers. As you can see in A, that is basically talking about the reserved powers of states being able to pass legislation such as medical marijuana, and there are a couple of states in the U.S. that allow regular recreational marijuana. There is no federal ban on marijuana, so there's no law that prohibits or would enact the Supremacy Clause to ban marijuana. Then you also see that there are some scenarios in which the Supremacy Clause comes into play, and one of those was marriage equality in 2015 in Obergefell versus Hodges, which we'll discuss a little bit later in the semester. The Supreme Court ruled in favor of same-sex couples for marriage equality, and that ruling created what's called a precedent, and that precedent supersedes any state laws that banned such marriages. So the Supremacy Clause really is enacted and at its core states that when laws are in contention, the federal law supersedes the state law. So let's continue on our journey. We've talked about the development of the Constitution, several compromises that had to be made by our founding fathers, how powers were allocated. And so now we're going to talk about what's called the ratification process. So how did the Constitution get approved, and how did the Constitution become our supreme law of the land? So although delegates to the Constitutional Convention approved the final draft of the U.S. Constitution in September of 1787, the terms of the Constitution itself prevented it from entering into force until 9 out of 13 states had ratified it. 9 out of 13 states had to agree to adopt the Constitution before it would become the law of the land, or what's known as the ratification of it. States convened ratification conventions to debate the merits of the Constitution and vote on it. And then there were several different campaigns. So think of it this way. So the we'll talk about the Federalist and Anti-Federalist here in a minute, but there were two opposing parties that one wanted the Constitution, one did not, and so they, after the convention, they went out and campaigned for their stance, and they utilized different avenues to campaign. So delegates to state ratification conventions debated many of the issues that provided problematic during the Constitutional Convention in Philadelphia. The power of federal government and whether the Constitution went far enough to protect individual liberties was a source of strong disagreement. So here's where we're going to get to. You had the Federalist and Anti-Federalist. The Federalists were the ones who favored ratification of the Constitution as it was laid out in the Constitutional Convention. Those that opposed it were known as the Anti-Federalist, hoping to sway public opinion and votes of the delegates. Both the Federalist and Anti-Federalist wrote numerous newspaper articles arguing for and against the ratification of the Constitution. So think about it this way. The Federalist and Anti-Federalist utilized the media outlets of their time to sway public opinion, which is very important because that still happens today. So remember back at the beginning of this lecture, I talked about how, the media can kind of create their own narrative. Here, the Federalist and Anti-Federalist were utilizing the media to create a narrative either for or against the Constitution. Prominent Federalists Alexander Hamilton, John Jay, and James Madison published a series of essays in support of the Constitution and in support of federalism, and those became the Federalist Papers, which you will read next week. The Federalist Papers were persuasive essays that were written in support of the new Constitution. So particularly, I think you're going to read two of those papers. Federalist 51 was written by James Madison, and in it he really talked about the separation of power between the three branches. And then Federalist 10, which was also written by James Madison, spoke about how special interests would not seep into the government due to its diversity. So these essays originally appeared in newspapers, and they were published in 1788, and they are known as the Federalist Papers. If you have a hard copy of your book, you will note that both of those Federalist Papers that I talked about is published in your book. If you do not have a hard copy, which you do not have to have for this class, I will post the PDF of the Federalist Papers that you will read next week. All right, so let's go back to the ratification process. So in June of 1788, New Hampshire became the 9th state to ratify the Constitution. New Hampshire was the 9th state to ratify the Constitution, thereby reaching the requisite number of states for the document to enter in force. However, in the political reality, it really required that the populous and powerful states of Virginia and New York ratify it in order for it to become a federal form of government to work effectively. However, once New Hampshire ratified it, that's all that they needed was the 9 out of 13. Virginia ratified the Constitution in June of 1788 because there was a promise that there would be some amendments that would be related to civil liberties, which was a concern of those that were holding out. And then the Constitution came into effect on March 4th, 1789 in full force. And so this is just a picture from your textbook that is a timeline. It's a really cool timeline that kind of tells you when each state adopted the Constitution. One thing I wanted to point out, notice that Georgia was one of the first states to adopt the Constitution. Thought that was really cool. So there have been amendments. One of the things about the Articles of Confederation was that there, while there was a process for amending the Articles of Confederation, all 13 states had to appear and agree to do that. That process never happened because they could never get all 13 states. So the Constitutional Convention recognized the problem caused by its unanimous consent requirement, and therefore enshrined a less rigorous process to amend the Constitution. And in total, the Constitution has been amended 27 times. Might be important. All right. Article 5 of the Constitution provides the amendment process. And it says that Congress may propose an amendment which must be passed by 2/3 approval of both the House and the Senate, or, excuse me, the states may call for a national convention which must be held after approval of 2/3 of the state legislatures, and the National Convention may then propose the amendment. Okay, so we've talked about how to propose an amendment. So after that amendment's been proposed by either Congress or the National Convention, the amendment has to be ratified by three-quarters approval of either the state legislature or the state ratifying convention. So either 3/4 of the state legislatures have to ratify it, or states can call conventions to ratify it. After an amendment is proposed by either Congress or the National Convention, Congress chooses whether it must be ratified by state legislatures or state ratifying conventions. So Congress has the power to choose by which method the amendment is going to go through, whether it goes through the state legislatures or whether they're ratifying conventions. The 21st Amendment, which repealed prohibitions under the 18th Amendment, is the only amendment ever approved by state ratifying conventions. So the majority of amendments goes through the state legislature process, where 3/4 of the state legislatures have to approve the amendment. So the next couple of slides just kind of talks about some key constitutional amendments and just kind of touch on. We'll go into some detail in these further throughout the semester. But in September 1789, Congress proposed 12 amendments to the Constitution, which primarily addressed the concerns of the Anti-Federalists around the civil liberties debate. It's worth noting that state legislatures ratified 10 of the 12 proposed amendments, and those first 10 amendments are known as the Bill of Rights. In the aftermath of the U.S. Civil War, Congress proposed amendments to abolish slavery and address the rights of free slaves. These amendments, ratified as the 13th, 14th, and 15th Amendments, provide for protections of civil liberties and civil rights. Some other significant amendments. The 17th Amendment provides for the direct election of U.S. senators by voters. The 19th Amendment provides women the right to vote. The 24th Amendment abolishes poll taxes and taxing on voting used by southern states to disenfranchise African American voters, which we'll talk about during the civil rights topic. The 26th Amendment lowered the voting age from 21 to 18. So those are just some notable amendments. All right. That was chapter 2. We have reached the end of our discussion this week. Here are some key takeaways that I want you to make sure that you fully understand. If you missed any of these, feel free to go back through the lecture. But the history of breaking away from English rule was brought about by concerns over taxing and lack of representation in decision making. The Declaration of Independence was the document that proclaimed the U.S. separation from British rule. The Articles of Confederation were the first true written agreement between the states to form some semblance of government. However, it was riddled with issues. Specifically, the Articles did not provide federal government with significant powers. Those powers all remained with the states under the Articles. The Constitution was an answer for the issues with the Articles of Confederation. It was a tumultuous process to get the Constitution ratified, with media playing a huge role through the Federalist Papers and other campaign activities. Articles 1 through 3 lay out the 3 branches of government: executive, legislative, and judicial. The Constitution gives explicit powers through the enumerated powers. However, there are implied powers that are known as reserved powers. The Bill of Rights are the first 10 amendments to the U.S. Constitution, and the Constitution has been ratified or has been amended 27 times. All right. I hope you guys enjoyed learning about the history of the development of the U.S. Constitution, its origins, and kind of the power structures and plays that has gone through this week. I look forward to talking with you next week, and as always, if you have any questions, feel free to reach out to me.